Thank you very much, and good afternoon, ladies and gentlemen. I'll start by digging a little bit into the definition first, and I know that Judge Jan Forrester actually has provided upfront a very good definition of what a standard is, and therefore I will not repeat that. I will simply jump directly to the definition of open standard. An open standard is a result of a careful balance between the balance of interest among the different stakeholders in a contribution-driven environment, and that environment is controlled by the governance of the SDO itself, by the technical working procedures, and of course by a very key piece of information which is called the IPR policy, the policy by which the SDO regulates the availability of licenses for standard essential patents. And that's about it. This is the subject of the conference. Basically, I would repeat here and highlight open standards is a consensus-based process. The process is transparent. Materially affected parties are not excluded from the process, and basically the IPR policy, which is based on the RAND or FRIEND intellectual property rights policies, do not mandate, but may at the option or voluntarily by the patent holder accept the fact that it is constrained to royalty-free, that is to say without compensations, and sometimes also other terms and conditions may be pre-programmed by the SDOs. The overall reason why open standards do work and are defined by such a process is because we want at the end of the day that the standards, the products of those SDOs are used by implementers worldwide, if possible, and available to these implementers on reasonable terms. Right. So the IPR policy of an SDO is there to ensure the widespread dissemination of these open standards, and they rely on the commitment by the patent holder to grant a license of those SEPs, standard essential patents, to all the potential licensees, not to all the implementers, to the licensees. I will tell you why later on those fair, reasonable, friend terms, subject to the condition of reciprocity, because that is already one self-regulating mechanism that ensures that this commitment, which is one way towards the potential licensees, ensure that if the licensee holds standard essential patents, those will be available to the one that actually has made that commitment up front as well. But then it leads me to the following. Reasonable. What's the meaning of reasonable? And indeed, it cannot be anything else than qualitative. It cannot be solely quantitative. It's not about what is the value of the royalty. No, it's not about that only and solely, exclusively. It actually is, you have to have reasonable terms and conditions in the license. And those you cannot quantify, you need to qualify them so that they are generally acceptable in the negotiation between the SEP holder and the potential licensee. And therefore, the whole IPR policy spirit in the way it's been drafted is assuming fair play and good fair dealings between, on the one hand, the SEP holder and the potential licensee, and both of them need to negotiate, and that's it. And you will achieve the best efficiency, that is the lowest possible and good and fair return on investment for friend, if the two parties conclude in negotiation, rapidly, timely, a license. Anything that adds to the burden is likely to increase the cost, and I think the previous panel has actually touched upon this element. What the policy cannot do, and because it's a policy, it's looking forward to give the rights and obligations, so it gives the positive effects expected by the policy. It cannot deal, it's impossible task, even by engineers or lawyers alike. You cannot come to an exhaustive list of all the abuses, bad cases, etc., bad conducts. That's for court cases or judges to decide upon who was bad or not in conduct, or who has been abusive also in their dealings. And we've been speaking a lot of hold-up, Gunnar and others. Let me take one step backwards. I'm not an economist, and I would like to permit myself to say, okay, I'm not looking at the sole definition, strict definition hold-up economists has come with. I like to look at it in terms of abusive conduct, and therefore I come with the perspective here, and let me assume that for the rest of the presentation, that abuses can be performed and exercised by both parties, basically the SEP holder on the one hand, and also prospective or potential licensees alike. I mean, it's possible. And here is a list which is absolutely non-exhaustive, but you can think about the following question, reading yourself the list. I'm not going to go one by one, but have you experienced any such case or conduct or let's say abuse, and how did you react upon that? I think that's a key question to be asked. Now, let me just highlight the following with the timing. Last one, the patent holder may be seeking a license from potential licensee at the very last end of the process, even too late when the locking effect is there. But also look at the perspective that a potential licensee may not be willing to negotiate to actually take that license. And that is creating also a problem. So that leads to the debate we had in the previous panel, and it is repeated over here. I submit that there is a lot of good regulatory means into the bylaws and IPR policies of SDOs, and it's been there, are either mandatory or optional. But basically, one thing, as an example, which has worked well, is, for instance, if upfront people would agree voluntarily that royalty-free license is the standard for that piece of work. And if people agree on that, including patent holders, well, we have a deal. We could have a license, a predefined license, even more, and let's work on that basis. If you do it up front, no problem. If you do it after the fact, once the standard setting has been in progress for some years, and you change the rule of the game, that is more problematic if you cannot reach consensus. Right, I was addressing the question in the bullet 3. There is a commitment one way by the SEP holder to grant a license, but there isn't any commitment or any obligation from the potential licensee to take a license. Well, because I think that is assumed. It's not written in the IPR policies, but if it cannot be concluded by negotiations, then it will be enforced by judges in court because there will be a dispute. Point number 6 here. There is currently no technical essentiality assessment for SEPs, nor SEP landscaping. There was no need to do that, but some SDOs are thinking that is in an area where they could devote some effort to look into whether that could be adding a regulatory means to improve the situation. And I will say no to this. Just touching number 7, there are some mediation arbitration mechanisms embedded in some IPR policies. The VB project is one of them, but it's never been used. And there is no example where it has been used on the planet, apparently. If you know, tell me. So basically, my conclusion here is that SDOs will refrain to be involved or to involve themselves into private licensing disputes because judges are there outside which can resolve those disputes. So, and also for good competition reasons, that is probably a very bad idea to get your finger into that area. Another limitation, I would say, of IPR policies is that it's a contractual benefit, and by this feature, it's only for the benefit of the members. It defines the rights, obligations of members. It cannot define something onto non-members. It cannot be binding onto non-members, except one thing, and that is coming next. Yes, I can go to my last page. Thank you. So if I could make a short summary of the last 4 or 5 years of lengthy debates in different SDOs, I would simply submit that there is a broad agreement that there is no agreement on, and there is no consensus on, the existence of the patent holder problem as a systemic problem. I keep it short, just on purpose. There is also no consensus and no agreement that the reverse holdup is also a generic problem and systemic problem. There is no consensus that the meaning of reasonable shall adopt how is it called? The smallest saleable patent practicing unit that has been advocated in basically the damage theory in the US. That's not agreeable. And the number 3 there is no agreement that any implementer can demand a license for SEP from a SEP holder, demand if that party is not a potential licensee for that particular SEP holder. If the SEP holder is not going to look at this party as a prospective licensee, how is it that this party can actually demand a license if it's not subject to a licensing program? On the other hand, there is consensus of one key element, and I like to spend just a second on that. The transfer of rights is an encumbrance on a SEP, which is then binding on any successor in interest. That is, any party holding that SEP in the future is bound by the original declaration by the SEP, the initial SEP holder. And finally, and last but not least, and I find it refreshing, participants in our debates are looking for means to improve transparency of SEP declarations. I don't know what it will result into after it's been discussed, but it's an interesting area where there is some traction. And also people are looking into the possibility to offer software under one of these open source licenses in a way which is compatible, I would say, with the spirit of the IPR policy. And that is really a refreshing perspective for the next meetings this year and the coming years and the years after that, but I hope I will not survive all these years. Thank you very much.